Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking at a book from Rory Derham. It's from OUP as well, Oxford University Press, and it's Derham on the Law of Set-Off in the 4th edition. This book here, 1500 pages, standard sort of structure inside. You've got the paragraph numbering, lots of footnotes, a very useful index at the back, and there's a smallish biography, a bibliography rather, which is there, but it's got everything you need to know really about the law of set-off, which of course is a much more important thing than many people often think about. Certainly I've been guilty of that in the past. I've gone to see a client and it's not been the forefront of my mind, and sometimes it comes to the forefront of my mind quickly because that's what the clients are really thinking about. There's a review which Elizabeth and I have written on Flickr and all the main websites, and we've given it this title because this gets to the crux of what Rory is up to. It's The Right of Set-Off, When Is It Available? Now in a new 4th edition, an exposition of the most important principles, but not the pleadings. And that's really where we're at, because this is not about pleadings, it's about the concepts and principles behind set-off. So as Australian lawyer Rory Derham points out, the business community does wish to attach the right to set cross demands against each other, particularly in the event of insolvency, and it's a subject which arises regularly in court-held conferences. The publication, therefore, of the 4th edition by OUP is timely in our view, particularly at times of economic challenge faced in the second decade of the 21st century. I think the important thing to bear in mind here is that it will be a question a lot of clients will ask you: when can we set off some of the money against the other? Because when you have any form of dispute, it's never clear-cut, so you always have to bear these types of mechanisms in mind. The original aim of the work, which is more than 1,000 pages and 18 chapters, was to examine some of the more important principles of the law of set-off itself. The question of when a right of set-off is available is obviously indicative from the principles which we have from decided cases and so forth. And the new edition examines a number of important developments which have taken place in the law set-off since the 3rd edition some years ago, and covers, for instance, things like the Insolvency Amendment Rules 2005. There's a useful decision which I think many will find helpful. That's Secretary of State for Trade and Industry and FRID in 2004, and Re-SSSL Realisations 2002 Limited in 2006. These are obviously matters of mutuality, and of course that is very much part of the issue of principles. Other pertinent cases relating to this vast topic are listed in a 68-page plus list of cases. And obviously you've got the standard tables of legislation, SIs and so forth. Remember, of course, also that you've also got other jurisdictions covered here, so we're not just looking at England and Wales, we're looking at much wider areas, the Commonwealth, obviously Bermuda, Hong Kong, New Zealand, UK, Australia and so on. Indeed, the author considers the principles of set-off from both an English and an Australian perspective, which I think is helpful, thus giving us a much more of a global concept of where we're going with this subject. It's definitely a practitioner's reference book, and speaking of vast, not just one looking at the table of contents, it's very big in all senses of the word, and it should be enough to convince the most demanding practitioner of the depth and breadth of the subject, which is obviously complex. Starting, obviously, as it does with the meaning, importance and forms of set-off, the work then contains a wealth of material which deals with everything in our view, from substantive equitable set-off and set-off in bankruptcy and other types of liquidation. And there's obviously a lot more to go with that. So if you're a practitioner and you're in any way involved in this area of law, I'm sure you will find it extremely helpful. The law is stated as at the 15th of May 2010, and as I say, it's about principle as much as it's about the practical concepts we face. Unfortunately, it remains well outside the complexities of the pleadings. So thank you very much to Rory Derham and to OUP. Thank you, bye-bye.